Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about divorce and family law along with my co-host Jesse Barrientos. Jesse, welcome to the show.
Thank you, Dave.
How you doing today?
Oh, very good. Yourself?
I'm doing well. Let's jump right in, Jesse.
Sure.
55% of married couples end up in divorce court. A certain percentage of those are uncontested, but I believe a greater percentage of those are contested to some extent. So let's talk about contested divorce. Where do we start?
Well, everything starts with the filing of a petition for dissolution of marriage. Now, a lot of times what will happen, a precursor to that, will be what you call an order of protection. I know we've done shows on that, and we probably should just mention a little bit about that. It's the Illinois Domestic Violence Act, and somebody can go in ex parte, that means without the other side, and tell the judge, this person, my spouse did this to me or that to me, and obtain an emergency order of protection for 21 days. And then there'll be a hearing after that other person is served, and then the judge will make a determination of whether or not that should happen or not. Again, I say that because orders of protection are overused and they're used inappropriately for that purpose in order to get the other person out of the house, because that's one of the remedies under an order of protection, exclusive possession, and in order to get temporary custody of the children, and then they file their divorce, and now I already have the house and I already have the kids.
Well, isn't that an incredibly sad state of affairs that I started talking about divorce and you immediately went to an order of protection precipitating the divorce?
That's right.
I mean, that's just, is everyone so violent that we need an OP before we can start a case?
It's not that they're violent, but whether or not people have friends or whether or not their attorneys have told them that, or for whatever reason, I see that a lot, that is kind of a, that precedes the divorce, just so that you can have, some people think it's a tactical advantage. I think that that's ridiculous. I think, again, that's what I said earlier, that it's kind of overused and it's inappropriate to use it for that. Order of protection was meant to protect somebody who is truly being abused. And that certainly happens, and it has its place where it's supposed to be. But that being said, it's initiated a dissolution of marriage by filing a petition for dissolution of marriage. And depending upon what county you're at, the fees might be a little bit different. And then, and we're talking about a contested divorce here, and then what happens is that the summons is placed with the sheriff or a special process server in order to serve personally or substitute service the respondent in the order or in the dissolution of marriage case. And so once that happens, then that other person has 30 days from the date of service to file his appearance. There's again a fee for filing your appearance, and then an answer to that dissolution of marriage, basically stating, admitting the allegations or not admitting the allegations, and those kind of things. But a lot of people, litigation is expensive. A lot of people will do, if they're kind of in agreement and if they're in a certain income level, they'll be able to do that on their own. And that's what you were talking about earlier in terms of the uncontested ones, where they're already in agreement, all the paperwork gets taken care of ahead of time. And we'll talk a little bit more about that, the judgment and the support order and maintenance if it's applicable and everything else. That's all hammered out ahead of time. Everything gets filed in one fell swoop, including the appearance of the respondent, and then what they call a prove-up date is set. And so that goes really quickly. You'll save yourself a bunch of money. But then in the contested, and I know you do divorce as well, what's your kind of experience, now after you've kind of filed this and you've got service on the other side? What do you think you do, or what do you do when the other person doesn't file their appearance?
Well, if they don't file their appearance, you're going to go ahead with a motion for default and proceed with the judgment without that person ever appearing. So basically, whoever is the one who files is going to get pretty much whatever they want within reason, as long as the court doesn't find it to be unconscionable. But in most of my cases, someone is going to file an appearance, either pro se, meaning by themselves, or through counsel. And then from there, we're going to get into discovery, certain motions, down the road maybe a pretrial. But let's talk about a case where someone goes to mediation and tries to reconcile the marriage before anything is ever filed in court. And once that mediation or reconciliation fails, they kind of take an agreement that the mediator came up with that they can work with, and they want to incorporate that in the divorce court.
Well, I mean, you can do that a couple ways. Really, mediation for purposes. I mean, if you're going to try to reconcile, and I always ask, I'm a mediator in DuPage as well as a garden ad litem, which is an attorney who looks after the best interests of the children. And my mediations, and there can either be court ordered, because most of the different counties have local rule that says, hey, if there's an issue on custody or visitation, they're going to send to mediation to try to work it out. And if not, then you'll go through the rest of the process. Or it can be, like you said, where people, hey, listen, you know what? We want to save some money. We just want to see what we can do, and let's try to work it out. There's only a couple issues. And so that mediator is in charge of the process, and the parties are in charge of the outcome. It's the mediator's job, and he's a neutral, disinterested person. I don't care what happens one way or the other. I'm just trying to help those people come to an accord. And a lot of times there are deep-seated hidden reasons why people don't want to do something or why they want to do something. Just for example, I've had people who didn't want the other spouse to be able to have overnight visitation. Okay, and as we're talking, we kind of discover what's the reason for that. Oh, well, this person is going to take the child out of the country, and I'll never see my child again. Okay, but you're okay with the other spouse having visitation, not overnight, but maybe from Saturday morning to Saturday evening, and dropping the child off and then having them again from Sunday morning to Sunday evening. Oh yeah, I'm okay with that. Well, what's to stop the spouse from taking the child out of the country during the time he has them? So that's not the reason why the person doesn't want them. The person doesn't want the spouse to have them just because that person kind of knows that, hey, listen, that's going to hurt you, or, they just want to exercise and exert some kind of control or authority over the whole situation using the kids, and it's completely inappropriate to do that.
Right. Now, to proceed with a divorce case, the person filing the case must allege specific grounds provided for in the Illinois Marriage and Dissolution of Marriage Act.
Right.
Let's touch upon some of those grounds, starting with the most common, if you would, irreconcilable differences.
Irreconcilable differences means that you just can't get along. In any divorce action, you have to have grounds. And irreconcilable differences in Illinois is the no-fault ground. It means you just can't get along.
Okay, so that'd be Rodney King and the LA Police Department.
I don't know about that. It's possible. Just can't get along. The difference with that, though, with that ground is you have to be living separate and apart for a continuous period of time in excess of 2 years.
Oh, but you can reduce it.
You can reduce it. All of it except for 6 months can be waived by an affidavit. Now, living separate and apart doesn't necessarily physically living separate and apart, because a lot of times, especially in this economy, people are still living in the same house. They've just moved to a different bedroom, or they're even sleeping in the same bed, but they're more like roommates. They haven't been intimate with each other, and that's also been construed to kind of add the time up in terms of living separate and apart for that period of time. There is mental and physical cruelty, which is just what it says. Obviously, physical cruelty means, I hit you, beat you up, or push you around, or whatever. Mental cruelty can cover a whole bunch of different things. What kind of things, Dave, do you think that covers?
Well, if someone says that they don't wish to be with them, they don't love them, they humiliate them, they call out all their faults, basically engage in a conduct that causes someone to be stressed, feeling lower self-esteem, lower self-worth. That would be mental cruelty, a constant barrage of insults and attacks.
You don't contribute anything to this household. I don't know why I put up with you. Why can't you do anything right? Those kinds of things.
Beyond bickering.
Right.
It goes to another level beyond bickering where it actually is hurtful. And the person giving the information knows that it's hurtful and it's intended to be hurtful.
Right. It's intended for a punch there below the belt to make you feel that way.
Right. Let's talk about the sexiest grounds. Adultery.
Adultery. Well,
How do you prove it, Jesse, when you cannot get a witness to testify and your spouse will not admit it? How do you allege and prove adultery?
Well, you can certainly allege adultery, but this is the other interesting thing about this too. And a lot of times they allege grounds in the alternative. They'll always allege irreconcilable differences in the alternative. But adultery, I believe, that can be construed under mental cruelty as well. That certainly, I believe, would qualify. How do you prove it? Okay, well, hey, you have one of the spouse, your clients, kind of testify that, hey, listen, there's been phone calls, your husband has been, or wife, because it could go either way, has been going out, you don't know their whereabouts, there are strange calls at night, there are charges for hotel rooms on the credit card, or you caught them in the act and you talk to the person, because a lot of times that's how those things open up. The person with whom the spouse is cheating or having an affair wants more of that person, and or you tick her off or tick him off, and they talk to the spouse to get you in trouble, and then there you go. You find that out. Also, another way to do that is with a private investigator. And of course, those kinds of things cost money to pay. Depending upon what that person's hourly rate is, a private investigator will follow somebody around and keep tabs on them, and they could, there's a presumption, obviously, they might not catch you in the act, but if you go into a hotel room with someone who's not your wife or not your husband, the inference is there.
Right. Now, it's important to note that marital fault does not lend itself to a separate division of property or a different amount of
Doesn't
debt,
matter, right.
or a different amount of support.
Right.
So we're a no-fault state, but we also do not benefit the non-party that doesn't commit the fault. They don't benefit by someone else doing
Right.
something.
It doesn't matter whether or not the ground is adultery, mental and physical cruelty, irreconcilable differences, another one we're going to talk about.
So it doesn't pay to hire the investigator to catch somebody fooling around when you have mental cruelty or when you have irreconcilable differences, because you're going to be entitled to your fair share of the marital estate, and you're going to be apportioned your fair share of the marital debt, regardless of fault. So why not go the easier route in terms of time and money?
Well, because people have this idea, and it's a matter of principle like anything else. People want to prove that their other spouse or that their spouse had cheated on them, right? And so they're going to want to do that. And I agree with you. It makes no difference whether or not you use any of those grounds. And interesting to note here is that a lot of times, and as I said earlier, we allege alternative grounds, because a lot of times, even though a divorce may start out contested, it may end up in agreement after the whole process, and we'll talk more about that. But no one is going to admit that they're an adulterer, that they've been mentally or physically cruel, or that they've been habitually drunk, or that they've, abandonment's a whole different thing. Basically, you have to be gone for a year, and that person's out of the picture, but then that gets into a publication divorce, and if we have time, we'll can kind of talk about that. But some people want to put the thumb on that person. It's important to them, hey, listen, this is what you did. I'm with you. The path of least resistance. If you want to just get the dissolution of marriage over with, then hey, don't worry about that. Don't spend that amount of money. But people have all different kinds of thoughts in terms of what they want to do. There's one thing, though, I want to talk about, Dave. You mentioned earlier about default judgment, about not responding to the petition for dissolution when you're served. And I just want the people at home to understand this and to know, putting your head in the sand is not going to help you. If you don't respond to that and you don't do what you're supposed to do, bad things will happen to you. I promise you.
And that goes beyond divorce. That goes anything in life where you're required to respond or take some sort of responsive action, and you don't.
Absolutely. So I just want to make sure that, hey, if you get that, okay, it's important to do something. What is something? Okay, something is to see a lawyer. A lot of lawyers, including you and I, offer free consultations. Also, there is, depending upon your economic level, there's legal aid. Prairie State Legal Aid. There's a lot of different services or different private, not-for-profit organizations that also do pro bono. Pro bono means no charge for the legal fees. Right. But you have to fall within whatever the category that they've set, the threshold for income and everything else. So it's important to at least get some advice. And then, if you're going to do what you said earlier, pro se, mean representing yourself, then you want to make sure that you go in there and you file your appearance. If you don't have the money, you might be able to get a waiver of the fee if you can demonstrate to the court your income level is below whatever threshold that is. And so then you won't have to pay whatever the appearance fee is, and you won't be in default, and you kind of go from there. So I just want to make sure that everybody kind of understands that.
Okay. Let's talk about civil unions and divorce with that regard. We're seeing more and more civil unions, but are you seeing more and more divorces in those cases?
It's the civil union law just recently kind of took effect not too long ago here, and so haven't gone really through the mill yet in terms of the kind of things that are that are happening. But theoretically, and I say theoretically, everything should be very similar or substantially similar to a dissolution of marriage action.
Right.
The only difference is that there are two same-sex partners.
Okay. In those cases, would you still allege alternative grounds?
Absolutely.
Okay.
Yeah,
so
everything
really,
is the same.
all right, let's talk about child support. There's statutory guidelines and then there's reality.
Well, that's true.
What is someone entitled to if they're the custodial parent and there's one child? What is the state guideline for that?
The statutory guidelines for child support is, for one child, is 20% of your net income. And
Now, how can that be the case, Jesse, when you got people who make anywhere from $15,000 to $250,000? 20% between those two
Right.
is a drastic amount. And obviously, at some point, it's too little for the child, and at other points, it's too much for the child. So how do you reconcile that?
well, both parents have an obligation legally, a responsibility, and
If it's their legal child.
if it's their child, and not to mention anything of the moral implications, to support your child. That's your child, okay? So you have a duty to take care of that child. It's not about your convenience, okay? It's about the care and upbringing of that child. And so when you look at what you said, they also look at other things in terms of, hey, when you look at the kind of standard.
Well, the financial
kind of during
resources
marriage.
of the parties
Right.
does come into play.
Exactly. For example, if you're looking at 20%, now guidelines are just that, they're guidelines. Most of the courts will adhere to what the guidelines are. However, there might be a reason to deviate
Many
from the
judges,
guidelines.
though, don't want to get a reputation that they'll deviate.
Well, it
'Cause
depends.
deviation takes a lot more work.
It does.
And then more counselors will come before that judge seeking a deviation.
They have to make a finding, but the thing with deviation, it can go upward, in other words, beyond the 20%, or downwards, below the 20%. And so a good reason for a deviation would be downwards. So let's say that I'm supposed to pay my 20% for child support, and we're during the divorce here, you know what, I'm going to give you the house. There's some equity in the house. There's $50,000 of equity in the house. We would have, if we were going to split it equally, it would be $25,000 apiece, or whatever number you want to pick. All right, so I'm just going to give that to you. And so, kind of as a little bit of an offset, that would be a reason. Judge, we're giving her the equity in the house or him the equity in the house. And so the child is 17 or 16 years old. There's only a couple years. And so the child support should be deviated to something less than that, because essentially, basically, we kind of pay that up front. Now, we don't know what you're going to make in the future, it's true, but when you have something similar like that, it's only going to be a couple years, and that kind of gets considered. Let's take the extreme. Let's say I made $5 million a month. I don't, Dave, but if I did, that would be fantastic. And if I did, now, does the child need 20% of that a month?
No.
No. And so we would look at what the needs are of the child. We would look at, because child support is, you can't just have an accounting of it. I have a lot of people that come into my office and they say, you know what, I just want to put everything into account so I can see everything that she's paying for, for child support. I want to know, when she buys these diapers, or when she buys. It's not for that. Child support encompasses not only those type of things, but it also encompasses the roof over your head, your utilities, which your electric, your gas, whatever else
Right.
that you have, the internet, all those kind of things, your heat, all that stuff.
Yeah. Unfortunately, many custody battles are simply for the fact that the person doesn't want to be obligated to pay child support.
That
So if they
happens a
can
lot.
win custody,
Yeah.
they can either reserve the issue for the other party if they can't afford it, or they can pursue it against the non-custodial party. So a lot of men, in my particular cases, don't understand that the obligation to pay child support is going to be for the custodial parent, but that doesn't mean that you are going to be found to be in the best interest of the child to be the custodial parent.
Right.
In fact, many times, if the man is the one who is out working and the wife has been home raising the child, common sense would say that situation should continue. And the court does often maintain the status quo. Is that correct?
They surely do, because if I'm out working and I'm not at home, where is the child going to stay with? A sitter, depending upon the age, preschool, school, all right? And if the other parent, as you said, was the one at home raising the child, and that person has performed the, well, menial tasks. I mean, really, that's what they are. I mean, they may not be menial in that sense, but hey, when you're doing the cooking and you're doing the cleaning and you're doing the shopping and you're preparing getting the kids ready for bedtime and making them take a bath, again, depending upon their age. I mean,
all of that is
things.
harder than a regular job.
Yeah, I would say so. And so, it really depends, but you can't just exclude that based upon just that factor. The truth is that each situation is unique to itself, and so it really depends. And what the courts will do, as you said, will kind of look at what's in the best interest of the child, where should that child be, and they'll either appoint a guardian ad litem, which is an attorney that, it's not necessarily an attorney for the child, it's an attorney who looks after the best interest of the child. A guardian ad litem, and there's a guardian ad litem, there's an attorney for the child and a child rep, and each one of them has different functions and different responsibilities. Some of them can participate actively in the litigation, some of them can't, some may have to write a report, some of them can't, some of them can be called on the witness stand to testify, and some of them can't. And so it just depends on what it is. But a guardian ad litem doesn't have to listen to what the children think their best interest is, but based upon that person's investigation, what he or she thinks is in the best interest of the child.
It sounds like a lot of governmental intervention.
Well, there's no other way, really, when you're trying to determine who the best interest of the child is. When people are fighting for that child for custody, what are you going to do? You have to do something. And
can't the judge interview the child in camera?
That's also an option, but so much more is required. That's just one factor in the bigger picture in terms of where the child is going to go, is the wishes of the child. And so the older the child, the more weight his or her wishes are going to have. And the younger, obviously an infant, is not going to be able to communicate or talk to you. And so that's just one of the many factors that the court looks at. There's also what they call, pursuant to the statute, 604B, custody evaluation expert, and that is a psychologist. That's somebody who is going to do psychological tests on the child and on the parties, and also going to do interviews and
really want to
look
mess
at documents.
This kid up, huh?
Well, not mess the child up. There's no other way. I mean, what would be perfect? What would be perfect? Hey, you know what? That if people were able to stay together, that's the way marriage was intended to be. Till death do you part, and then you all sometimes.
Yeah, but my point is, it's not bad enough that mom and dad can't get along. But now the child is being put through the ringer.
Well, and it's true. The child does get put through the ringer. And of any age, really, children are smart and they know exactly kind of what's going on. But in order to do the child justice, there has to be some measure of investigation. Judge has several hundred cases on his or her docket, and they can't go and conduct investigations themselves. So a 604B expert is really the court's witness. That's that person's kind of right arm, essentially, just like a guardian ad litem is. But the judge does not have to go along with the recommendations of a guardian ad litem or with that expert. Again, it depends upon what's presented, but that's the best way. And some judges prefer a guardian ad litem, some judge it because that'll get done a lot quicker than a psychologist.
This all comes at an expense, too. Who's paying for this child rep, guardian ad litem, attorney rep?
The parents are, and it could cost you anywhere from $6,000 to $10,000.
This is in addition to their own counsel that they're paying for.
Absolutely, absolutely.
Wow.
And if for guardian ad litem, what generally happens is if there's an order, and any party can move the court. That's how you get something before the court. File a motion to appoint a guardian ad litem or a 604B expert, as we were talking. And generally, for a guardian ad litem, both of the parties are going to split the costs. A lot of times, what I've seen for a 604B expert. A lot of times the judge will say the party that's requesting it is the one that's going to pay for it. Not always, because it depends on what the respective economic situations are.
I want to point out, too, this is a type of debt that cannot be discharged in bankruptcy.
That's right.
So this amount owed to the child rep, guardian ad litem, is going to stick around, even after a financial bankruptcy.
That's absolutely correct.
Yeah. Is there a class that the child has to take?
Well, not the child, but the parents. Depending upon what county you're in, the child or the parents.
Wait, the parents have to take a class?
The parents have to take a class, right?
Not the child.
No, and it's all about
I don't get that.
Well,
Help me here.
I will. It's about
Parents have to take a class about parenting.
But basically what they're going to kind of try to inform the parents on is the impact that a divorce has on a child. For example, a lot of times what happens in a divorce situation is that people will use the children really as pawns to get back at the other person, to hurt that person. They'll do what they call, a really hot topic nowadays, and it's true, it's called alienation syndrome, really.
Sure.
And what it is one parent will alienate the child from the other parent and tell the children, if they're with me all the time, your mother is no good, she doesn't love you, she's leaving us, she's just abandoned you, and it's sort of like a brainwashing. And so when they go to the other parent, they don't want to have nothing to do with that other parent. And obviously that isn't healthy for the children. Other things that are just kind of common sense for most folks would be not to discuss your situation with you and your spouse with the children. You don't say, well, hey, mom and I are getting divorced and, it's because of this or that or anything. You don't discuss that that's between you and your spouse. You don't send notes back and forth between, this is for your mom, or you don't send a child support payment through through the child. Here, give this to your mom. No, that's your business. You keep them out of it. They're already going to be impacted by this, and so you want to do everything you can to minimize that.
But as the parent going through this, they must realize that this is happening.
Some
this
of
isn't
them
like
do.
a shock that they need a class to realize this. They have to see what's going on with their kid and how they're all of a sudden, the personalities are changing, the school activities, the grades, the lifestyle. They have to see this blowing up in front of them, don't know?
Well, before that happens, one of the best interventions is education, as in everything. The more you know about something, the more you are equipped. But here's the difference, though. Just because you know about something, that's just knowledge. It's not wisdom. Wisdom is applied knowledge. So if I know about it and I don't do anything, then it really doesn't matter. But you've been informed and they've done what they can.
All right. Well, I think the kid needs the class, and I think the state of Illinois needs to mandate that the kid take the class so that the kid can be instructed that it's not the kid's fault. This is what happens in a case, and I think the kid should get a certificate. I don't think there should be a charge. I'm just kidding. There's too much classes is what I'm getting at. Back in the day, you got a divorce. There wasn't the child rep. There wasn't the guardian. The judge had to do his or her job, and a judgment got entered. I want to go back in time. I want to go back to those days, Jesse.
Well, but you need something in place as knowledge has begun to expand, people and psychological studies and everything else. I understand where you're coming from, because when I was little, we didn't have this syndrome or that syndrome or this or that or everything else. It was different. Now, one could say, okay, back then it wasn't diagnosed. They didn't know about it. And now they do. And so now they're just trying to provide the help that you need.
Okay, so if someone needs help, they can contact you, they can look you up,
Absolutely.
They can talk to you about their family situation, assets, liabilities, custody, support, visitation, retirement benefits. They can broach all those topics with you and get an idea of what could possibly happen.
Right.
And what it could cost and how long it could take and where it should be filed and whatnot?
Absolutely. A divorce is a division of the assets and liabilities, and of course of the custody and parenting time or visitation for the children.
Okay. Wow. So what's the best thing they should do? Should they do research online? Should they go to the law library? Should they just visit with an attorney immediately?
Well, you need to visit with an attorney to be informed. And we're talking about education being one of the most important things you can do to make an informed, intelligent decision. And so you need to go to a professional. No more than I'm going to diagnose somebody doing a doctor's job.
Okay. What a wonderful, happy topic, Jesse. Thanks for joining me today.
You
My
bet.
co-host, Jesse Barantes.
Thank you, Dave.
My name is David Siegel. We'll see you next time on Legal Action. Take care.